That takes us to one of the most important and powerful benefits to bankruptcy, whether it's Chapter 13 or Chapter 7 or Chapter 11. It's something called the automatic stay. What is a stay? In law, stay says stop. What stayed is stopped. You can't keep doing this anymore. And what stayed or stopped is all action by creditors against you as a person, against your possessions, and against the bankruptcy estate that's created when you file your petition. In practical terms, it means they can't call you on the telephone, send you bills, write you letters, sue you, garnish wages, seize money out of bank accounts, foreclose on property. In essence, what it does is it erects a legal brick wall around you to protect you from the depredations of your creditors. And if a creditor violates the stay after it's received clear notice, you can sue it in the bankruptcy court. And if you're successful, they have to cover your court costs and attorney's fees, which is highly unusual in American jurisprudence. In the United States, we have what's called the American system. Big shock there, right? And in the American system, if there is a dispute in court, each side covers its own legal fees, covers its own costs and attorney's fees. The British system, on the other hand, says loser pays the winner's costs and attorney's fees. Now, what that does is it tends to reduce the number of lawsuits because people are dissuaded from filing suits unless they have a very solid case. Now, in the United States, each side bears its own costs and attorney's fees unless either of two things hold. Number one, there's a pre-existing contractual right to costs and attorney's fees. So let's say we enter into a contract and the contract specifies that if either of us breaches the contract and the other has to sue to get either specific performance or damages, that the loser has to cover court costs and attorney's fees. The other is if there is an enabling statute. And the Bankruptcy Code has that enabling statute in Section 362, which is the section that deals with the automatic stay. So that will rake flesh off a creditor if that creditor continues to harass you after you are in Chapter 13. Now, be careful here. The idea isn't to be sue happy and, oh boy, I'm going to just go after that guy, both guns blazing. Sometimes there's just an honest mistake. Maybe the creditor didn't get notice of the bankruptcy filing. Sometimes the post office, for all of its efficiencies and inefficiencies, doesn't deliver everything in a timely fashion. So if after we file the petition, a creditor continues to harass you, I'll contact that creditor. I'll send them a nicely worded letter along with a copy of the voluntary petition and the notice of filing and ask them, please stop contacting my client. Please stop all harassment. And I'll also give them a call. And so then they've gotten notice from me twice. And of course, I like to believe that they got notice from the bankruptcy court, but that's not necessarily always the case. I might add that after I file the Chapter 13, I have to send copies of the Chapter 13 plan to each of the creditors. So in particular, that creditor that's harassing you. So they've gotten plenty of warning. And if they persist in that obstreperous behavior, well, then we're going to go after them both guns blazing in the bankruptcy court. But we do have to give them a chance to correct what might have been an innocent and honest mistake. Now, that is dealing with creditors harassing you, the debtor. What about my friend who, he co-signed on this and now they're harassing him? Chapter 13 has something that none of the other chapters have. It's something called the co-debtor stay. In essence, what it is an automatic stay that protects co-debtors on debts that you are servicing through your Chapter 13 plan. Gets a little bit tricky there in dealing with the co-debtor stay because if I'm not representing the other person and I contact the creditor and say, leave this other person alone, there may be a conflict of interest that I have to be concerned about. Most commonly, though, it comes up where one spouse has filed the 13, the other spouse didn't file. They're both on the debt, and the creditor understands, okay, I'm not going after the debtor who filed the petition, but I've got somebody else I can go after. In that situation, I will contact the creditor and say, you know, you got to stop with going after the spouse here, because the co-debtor stay of Section 1301 of the Bankruptcy Code says you got to leave all co-debtors alone. Anyway, so the automatic stay protects you, the debtor, when you file that petition, and then the co-debtor stay protects the co-debtor who is not a person who filed the petition with you. And in fact, the only person who could conceivably file a petition with you is a spouse. You have to be legally married in order to file a joint petition.